there was a settlement agreement at the deposition of the president of the corporation. He agreed on the record at the deposition that he would settle for a certain amount of money. He later backed out, on behalf of the corporation, backed out of that settlement, saying, I did not agree to that. I didn't understand fully all of the terms of the agreement. It was a rushed thing. I want to back out of that agreement. The court, when it entertained the motion under 664.6, said, we can't grant a motion under 664.6 because we don't have an oral stipulation on the record before the court. Here we have an oral stipulation at a deposition. That's not before the court. The prevailing party in that case also wanted to argue that there was a settlement in his favor on the basis of the letters that had exchanged in the mail between each other. They tried to, after this meeting at the deposition, to try and get that written down into written form. The court said, we see this transmittal of letters back and forth. We can't ascertain if there are any terms that were really agreed to by the parties. Therefore, there's no written settlement also that we can enforce under 664.6. The learning of 664.6, I think, is if you've got a settlement, you're concerned about holding on to it for whatever reason, first of all, go down to the courthouse and put it on the record. Any available judge will hear you. If you can get it reduced to writing to avoid that process in a very quick fashion, then you can. But if you're really in doubt, go down to court and get it on the record, and then you won't have to worry about filing a motion for summary judgment at a later time. So that's TCP section 664.6, which I think is very important to all of us. Bob, that moves us into our next topic, which is what's new in the area of jury trial.
Okay, Steve, four issues I want to talk about very rapidly relating to jury trial. One is when you get it, next is when you don't, third is how you lose it, and last is what you do if you don't like what you got. First, Maldonado versus Superior Court. That's the when you get it case. That was reported on by this channel last year. It stands for the proposition comprising to many of us that when a trial de novo from a small claims judgment occurs, that is to say a small claims appeal which results in a trial de novo in the Superior Court, in the limited circumstances of Maldonado, you're entitled to a jury trial on that small claims appeal. And that limited circumstance is when the small claims case involves an action for unlawful detainer. Now, when you don't, is a case that refuses to extend the proposition of Maldonado. It's not in your course material, but it's found at item number 28 of the supplement. That's Crouchman versus Superior Court. Crouchman says that you do not get a jury trial in just any old small claims court appeal. Crouchman, incidentally, also arises from a landlord-tenant dispute, but by the time the case reached the Superior Court, trial court, on the small claims appeal trial de novo, possession of the premises was no longer at issue. In a somewhat strained, logic-reaching, stretching opinion, the court held that Maldonado would not be extended, and the rationale for that is a little bit difficult to discern why a jury trial is available in one and not in the other, and I think it's obvious when you read the decision that the real basis of it is an attempt not to strain the resources of the Superior Court any more than possible. Otherwise, every agreed small claims court defendant appellant will be asking for a jury trial. Boyle versus Price Waterhouse Company at page 55 deals with the how you lose it aspect of a jury trial. Here, a associate in a law firm new to a case attended a trial setting conference and inadvertently checked the wrong box on the trial setting conference form. You guessed it, purportedly or on the surface gave up the right to jury trial.
And this is the end of the first half of the